we're more visible.
The appeal in the matter of the Queen on the application of Delve and another, and the Secretary of State for Work and Pensions.
Right. Can I please remind everybody that only the people, the judges, and the advocate who is speaking should have their video or microphones on. So everybody else, please, will you please cancel your video and your microphone unless you are speaking. Mr. Mansfield, I think you're going to open, is this right, for the appellants?
Well, I'm hoping everything's switched on. Yes, I can introduce matters in a moment when all the technology is correct.
Well, we can certainly see and hear you.
Thank you very much. Oh, my lords, and my lord and my lady, may I say first of all good morning, and also I'm not going to, unless you would like me to, deal with the representation because you're aware of it, but I can do it very quickly. Myself and Henrietta Hill and Adam Straw, my learned friends, are representing the appellants, two claimants. I'm not going to name them. I'll use the procedure as before and just call them the first claimant and the second claimant, if that's all right. And the respondent is represented, that's the Secretary of State for Work and Pensions, by Sir James Eadie and Julian Milford. May I indicate how we would intend to proceed, subject, of course, to your approval? And that is the grounds of this judicial review appeal have been split into 4, as you know. And the intention is to do this, that I will now give a very brief introduction, highlighting some matters which bear upon the appeal points in the following grounds. So that the ground number 1, which is put shortly as age discrimination, will be addressed by my own friend Henrietta Hill. It touches upon convention rights, and that carries over into ground 2, where she will deal with that aspect of ground 2. After her, my own friend Adam Straw will deal with ground 2, which is sex discrimination. And then the other 2 grounds, notice and delay, 3 and 4, I will deal with at the end. We've indicated time estimates, and I'm confident we can keep to those if it's of assistance. So, subject to approval, may I then just give a short introduction, bearing in mind that you'll be very familiar with a lot of the materials in the papers. May I allude first of all to the fact that this relates to a series of statutes. So those statutes are the 1995 Pensions Act, the 2007 and the 2011. In fact, just by way of indication, because it will be important certainly in the later grounds, these statutes deal with what's called the SPA, state pension age, and in particular we're concentrating on how it affects women. But there is a statute that obviously comes before all of these, that's the 1941, which set the age for women's pension at 60. So between 1940, there are other, 1995, the expected age was 60. If I can just briefly outline the statutes, no detail at all other than the broad outline. The 3 main statutes I've already indicated. One, in 1995, was the one raising the age to 65, but not to take effect then, but to take effect between 2010 and 2020. And the effect itself would be tapered. The 2007 Act dealt with the fact that by 2007, the state pension age for women and men was already the same. So it was that particular statute raised the joint state pension age of 25 to 66, 65 to 66. So the overall age goes up at that point, taking effect. I'm not going to trouble you with the years, but they're different years. So that's an intermediate statute, and it can't be necessarily isolated. The third one, 2011, accelerate that increase in age. It's brought forward, again to dates I won't trouble you with, but for women in particular, the rise of to 66 is itself accelerated to an earlier date. Now those three statutes have an important impact, and perhaps in this, if I can just detail this part of it, if it's easier, if there's no controversy about this, we set it out on page 17 of our the latest skeleton in the core bundle. So perhaps just to test that everyone's got the same documentation, it should be in your Lordships and Lordships bundles behind tab number 3, page 17 at the top. Sets out three groups that of women from the 1950s who are discernible groups as a result of those three statutes and the various dates within them. Should you, although I think it's a fairly dense exercise, the tables that relate to this, and I'm not going to go through them at the moment, can be found in this same core bundle from page 101 onwards. There are 8 pages of detailed tables indicating how the different ages are affected and when pensions become due. But for these purposes, in this introduction, the three groups set out at the top of page 17 are perhaps an easy point of reference. So again, for this group of 1950s women, the first group is the obvious one. In other words, any woman born before the 6th of April 1950 retains her state pension age of 60. So that's the first group created by these statutes. The second group are slightly more complicated because they are a group that may be defined by, again, age of birth, date of birth and age. It begins on the 6th of April 1950 through to the 5th of October 1954, halfway through this particular group, 1950s women. And the state pension age for that group it is not always going to be exactly the same. It's measured in months. You'll see it on the tables. But it's defined dates relating to their dates of birth. So it's rising incrementally and slowly between 60 and 66. So the state pension age is going up bit by bit for that particular age group. The third group, you will see on the top of that page, is people born after, women born after the 5th of October 1954, but before the 6th of April 1960. So that completes the 50 to 60 period, or cohort of people. They will have a state pension age of 66. So there are the three groups. One retains 60, third group are at 66, and there's an intermediate group. I hope that makes a little bit of sense. Now, this is important for this appeal because the two claimants in this case both fall into the third category. And I don't develop the argument, it will be developed later. The way in which this is structured is such that the women in the third group, that's after 5th of October 54, with a pension age of 66, are worse off than the ones in the second group, and obviously worse off than the ones in the first group. So that's an argument that bears upon the discrimination age point, which is made later. However, in order to develop the third group just for a moment, because again it bears upon all of the grounds that are going to follow, it may be illustrative, and I just take it as one example. If your Lordship and Ladyship could, therefore it's in our skeleton at page 15, but again, I'm just going to take the second claimant's case first for a moment, just to illustrate the situation as it impacts some of the women. And you will find that the details of the particular claimants are on page 14 and 15 of the skeleton. And I'm taking the second claimant, who is in fact in date order the first in time. It's at the top of page 15. She was born in 1956. Can I just run through the dates in her case? Born on the 23rd of September 1956, which means she would be 60 on the 23rd of September 2016. So that was the original date. However, with the changes, on the 23rd of September 2021, she reaches her 65th birthday. However, her pension, as a result of these changes I've mentioned, is not due now until the 23rd of September 2022. So again, she hasn't yet reached it, although she would have done under the system prior to this scheme. Now that series of dates is particularly important in terms of her situation. Now, the effect on her particularly, that is that particular claimant, it is set out in the judgment. And I think it's easier perhaps to follow it there because it's very succinctly set out. So if you very kindly turn to tab number 8 in the core bundle, page 87, there is one paragraph and one over the page. I would take just a moment to read these and make the point that, as it were, rather like the wheel of a bicycle, there are spokes that go off this hub into the ground. So paragraph 79, the date of birth of this second claimant is I've already mentioned that. The effect of the legislation is that she will attain her pension age at 66. I've already mentioned that. It's the next passage which I'd ask your Lordships and Ladyships to bear in mind when one's dealing with the legal aspects of this legislation. The second claimant has a number of chronic health problems. Now, may I pause there? It's not uncommon in this group, they're called by the court below the cohort of 50s women. It's not uncommon for women approaching this age to have already contracted various ailments and difficulties arising from.
Ooh.
Is important for this age group, and again has to be a matter to be borne in mind when looking at others. She was widowed in 2012. Well, not all fall into that bracket, but some do. She's in straitened circumstances, and my lords and ladies, that's not uncommon. That's very common in relation to this group by the time they even get to this stage.
I'm sorry to interrupt you, Mr. Mansfield. I noticed that on my screen the Master of the Rolls has disappeared.
No, I think I'm back now.
Right. You are, yes. Sorry if you were there all the time.
No. May I just check that your lordships have got paragraph 79.
79,
just
yes,
going
we're
through
following,
that one.
we're following 79, and you were saying it's not uncommon for women of this age group to have encountered various
Yeah.
difficulties.
So that I'm moving to straitened circumstances, and that, can I just pause on that? Because often the straitened circumstances arise from, but it's not all of them, but it's a very substantial number, because in many cases, especially if they are single women, they have had part-time jobs, low pay, and of course that has an effect on pension. And may I say, this is not, we don't treat it as a benefit but an entitlement for this particular group because they've contributed. But she was in straitened circumstances, and despite significant responsibilities for her elderly and infirm parents, may I stop there again, because that is also another common feature, particularly affecting women, that is the situation they are facing. So we have ill health, essentially a single woman at this point in terms of responsibilities, and she's had to go back to work part-time. Now this is important because in many cases they've had to give up full-time work, and they have given it up on the basis, and we'll come to notice in a minute, that they thought they were going to get a pension which would fill the gap. But they haven't got one. So they have to resort to a number of other, can I call them makeshift measures to survive. Here it's put as to make ends meet. Now this is very common amongst this group. And the sort of things that, we read out statements in the court below, I don't intend to do that here, but the sort of measure that they have to take is, for example, sell their house or their home maybe, to use up their savings that they've got, because in the case of the third group, who are basically having to wait 6 years, that is a considerable period of time, and also translates into a considerable sum of money. Because, roughly speaking, and you can see these figures in Mr. Gilchrist's statement, the annual amount that they will be not getting during the 6 years verges on, well, they're varying amounts, but it's around the 8,000 mark if it's a full pension. And you can soon work out that in some cases, the losses run into tens of thousands up to about 50,000. This is a substantial sum of money for women to have to, as it were, make up in a period when many of them would have thought to themselves that they're going to enjoy a retirement possibly with elderly parents or with grandchildren or whatever. I don't do more than just, obviously in the present circumstance, all of these factors are, I mean COVID-19, are exacerbated immensely. So going back to paragraph 79, she's frank about her lack of knowledge and her pension entitlement. And this is a portion of that's read out. If I just read these two, because again, they're important aspects. I had very little understanding of the pension system. Until recently, I understood that my pension age was 60 and my husband's was 65. My husband took care of all financial matters during our marriage, and he was the primary breadwinner. I first became aware of the change to state pension age for women in 2015. That is, in fact, 1 year, in the date chronology I gave you, just 1 year before she was due to receive it. When I overheard a conversation on the Metrolink travelling into work, I was stunned, as I'd heard nothing about it before, and I had received no letter from the DWP informing me of this change. Now, this bears upon the later grounds, obviously in relation to notice, and I'll have to return to it, but she, as an example, and she's not the only one, actually didn't get any letter, despite some being sent out. Maybe she was never sent one. Just going on in this, I mentioned the conversation to my colleagues within a couple of weeks of overhearing it. The majority, were not aware. So again, she's talking about herself and others. I went online and Googled the changes and stumbled upon the Back to 60 Facebook page. I just refer you very quickly over the page 88 at the top. There's a reference to the fact that we did have similar evidence from others that the court had in their bundle. So this is not an isolated situation. Now, may I just, as it were, round this section off, because the impact on this group, this cohort, they are in fact, they're in the vanguard. They're bearing the brunt, as it were, and shouldering the onerous situations that arise after the statutes come into force, as it were, in terms of actually being applied to them. It has been dramatic, and I'm not overestimating it, because these are words that are used by some of the others as well. This has been catastrophic for this group. And their lives, as you may imagine and you can understand from this, have been totally fractured, having to face a situation of the kind that this claimant, the second claimant, has had to face. Because besides the economic, almost poverty line existence that they're going to have to scratch around to make an existence, besides all of that, I think it goes without saying, you'd understand immediately the psychological, mental stress placed upon them, which reduces many people to an inability to actually even go and do what they need to do to make ends meet. Now, in parenthesis, may I just in passing indicate that there has been no, as it were, transitional buffer in the sense of any economic aid for this group, transitional provisions that might make the transition for this particular group a little bit more comfortable, nothing like that. For example, it's just an example. For men, however, there was an opportunity for men who were born in 1953, at the beginning of the end of that year, if in their cases, in 1953, if they were offered auto credit, which would be paid for by the state to make up their entitlement to a pension in the years 60 to 64 for them, because their pension age is 65. And the state would pay it. And that scheme survived until very, very recently. And many millions of men, approximately 4 million men, benefited. Now, one's not wanting to gripe at that, but what one's wanting to say very clearly, that hasn't happened for the women. That was promised to them, but it didn't happen. So we have a group of essentially economically and emotionally disenfranchised women. So it is against that background that we do submit that there are grounds for discrimination. And may I, on that note, kindly ask if Henrietta Hill could deal with ground one in that context. Thank you.
Thank you.
Good morning, my lords, my lady. Can I check that you can both see and hear me?
Yes, thank you.
I'm very grateful. My lords, my lady, could I start by asking you to turn up our grounds, please, at page 12B of the core bundle, just to help orientate you on which aspects I'm going to clarify, I hope, for the court. Behind tab 2A, and it's page 12B of the core bundle of documents.
Yes.
My lords, my lady should see that ground one, as my learned friend Mr. Mansfield has said, reflects the age discrimination ground. That is advanced solely now in relation to Article 14, and I will deal with that ground. Ground 2 relates to sex discrimination. My learned friend Mr. Straw will deal with sub-ground 1, which relates to the EU element of that ground. And then I will deal now, please, with all of the other arguments around sex discrimination that relate to the Convention. So little 2, 3 and 4 relate to the Article 14 ground. My learned friend Mr. Straw also made some further points on justification that I'll effectively adopt. So my lords, my lady, if it helps you in terms of orientating yourselves in the skeleton, can I perhaps ask you to turn to our skeleton, which you should find earlier in the bundle. And my lords, my lady, if I can ask you to turn please to page 18 of the core bundle. Forgive me, I'm sorry, it's page 17. You should see that our submissions on age discrimination, we set out the High Court's reasons at paragraph 10, and our submissions on age discrimination begin at paragraph 11 of the skeleton. And so, my lords, my lady, I will address paragraphs 11 through 17, and then come to the convention arguments on sex discrimination at paragraphs 44 to 60. My lords, my lady, I thought I'd structure my submissions in this way, if it pleases the court, simply to go through perhaps some of the non-controversial propositions around Article 14 quite briefly. I'm sure they'll be by way of reminder to the court, and then deal with the age and sex grounds. So, my lords, my lady, if it pleases the court, could I perhaps just take you to some non-controversial propositions around Article 14, and they're perhaps best summarised, if I can ask you to find in the authorities bundle, Carson v UK, which should be at tab 16 of the authorities bundle. It's internal page 298 if you're running from the electronic version.
Now, hang on, you'll have to, because you've got so many authorities bundles, which bundle is this in?
It's bundle 1,
Thank you.
and it's tab 16,
Thank you.
Carson v UK, and it begins at internal pagination in the bottom middle at 298.
Right. Yeah.
So, my lords, my lady, Carson v UK is, I'm sure, a familiar authority, principally looking at Article 14 issues, but through the framework of a residence condition. If I could ask you please to turn to paragraph 61, which is on internal page 315 of the bundle. My lords, my lady, will see beginning at paragraph 61 some fairly straightforward and I'm sure familiar propositions around the general approach to Article 14. And so paragraph 61 reminds us that differences in treatment based on a particular characteristic or status are capable of amounting to discrimination within Article 14. And it goes on to say on the third line down, and this is perhaps the Strasbourg concept of direct discrimination as we would know it in domestic law. In order for an issue to arise under Article 14, there must be a difference in the treatment of persons in analogous or relevantly similar situations. And such a difference in treatment can be discriminatory or will be discriminatory if it has no objective and reasonable justification. In other words, if it does not pursue a legitimate aim, or if there is not a reasonable relationship of proportionality between the means employed and the aim sought to be realised. There is further discussion around the scope of the margin of appreciation that I'll come back to. My lords, my lady, will see throughout this short summary of the key principles given by the Strasbourg Court that if one goes to 62, that where there is a complaint, as here, of alleged discrimination in welfare or pensions provision, the court is concerned with the compatibility with Article 14 of the system, not with individual facts or particular cases. And just two further short points, if I may please, over the page at 63. The court recalls that Article 14 complements the other provisions of the Convention. It has no independent existence of its own. And the test that one needs to apply is whether one is within the scope of one of the other Convention rights, rather than necessarily having to show a breach of one of the other Convention rights. And then at 64, in this particular case, the Chamber had found that there was no obligation on a state to create a welfare or pension system, But if a state does decide to do that, then it must comply with the Article 14 provisions. And there's reference there to the provision being within the ambit of Article 1, Protocol 1, the right to property. So, my lords, my ladies, that's the very broad framework in which the Article 14 complaint is advanced. Could I perhaps take you now just briefly to some key points around the different characteristics in issue? Could I ask you to turn, please, to the judgment in the court below, which you'll find at tab 8 of the 4 documents bundle. And if I could ask you, please, to turn to the text of Article 14 itself, which is at paragraph 44 of the judgment below. My lords, my lady will see that within the text of Article 14 at paragraph 44, sex is a protected characteristic on the face of Article 14, and it is accepted between the parties that age, although not on its face of Article 14, is also a protected characteristic. Finally, on these general principles around the characteristics, there is recognition in the Strasbourg case law of the ability to argue for combined discrimination, i.e. discrimination on the sense of more than one status. My lords, my lady, I don't ask you to turn it up, but within our authorities bundle at tab 54, which, forgive me, just bear with me a second while I get the correct reference for that. Forgive me, I'm not sure we have the reference for that case. I'll correct that later. But there is authority that I'm sure I can locate within the bundles for that proposition, and I don't believe it is contentious. I hope it's clear from our submissions that our arguments are based on both sex and age combined. My lords, I've taken you to the proposition in Carson around direct discrimination. Again, I don't believe this is contentious, but it's recognised within the Strasbourg jurisprudence that there is similarly a concept similar to our indirect discrimination provision. Could I ask you, please, to turn up within the authorities bundle? Again, it's within volume 1, my lords, my lady, and it's tab 19. And this is an authority that I think will come back to, the authority of JD. So could I ask you, please, to turn up? It's tab 19 within the authorities bundle.
So that's in bundle 2, is that right?
I believe it's still within bundle 1, but let me just check.
Yes, it's bundle 1.
I think it's towards the back of bundle 1. It's tab 19.
Oh, that's I only have, well, my bundle 1 only goes up. I'm so sorry, I'm misleading myself. I was looking at the wrong bundle. Yes, I have it.
I'm sorry for any confusion. It's tab 19, the case of JD.
Entirely my fault. Yep.
My lord, just very briefly, if I may, within JD, and it's a case that we'll come back to, it's a very recent authority from Strasbourg, there is a summary of the general principles. If I can ask you to turn up to paragraph 80, under the heading, the general principles. It's internal page 381. My lords, my lady, will see at paragraph 80, reference again to the concept of discrimination that is made out by different treatment between persons in relevantly similar situations. That's the burden principle at paragraph 80. That is the direct discrimination proposition. And then if one scrolls down, please, to over the page, paragraph 85. You will see there, my lords, my lady, reference to this proposition, that the Strasbourg Court has also held that a policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, regardless of whether the policy or measure is specifically aimed at that group. Thus, indirect discrimination prohibited under 14 may arise under circumstances where a policy or measure produces a particularly prejudicial impact on certain persons as a result of a protected ground, such as gender or disability, attaching to their situation. And again, there is reference to the objective and reasonable justification test. Just pausing there, if I may, my lords, my lady, I hope that that summary so far is non-controversial. And of course, I'm sure you've elicited from the skeleton that one of the issues between the parties in this appeal is the approach to be taken to the justification question, in particular the application or not of the manifestly without reasonable foundation test. And I'll come back to that, if I may, in developing the submissions, in particular around sex discrimination. So, my lords, my lady, that was the key principles under Article 14 that I wish to take you to. So could I please now turn to my particular arguments on behalf of the appellants around age discrimination. Perhaps it would be of assistance to look, please, at the way in which the court below dealt with the age discrimination issues. My lords, my lady, will see that this begins at page 78 of the core bundle, which is internal paragraph 43 of the judgment below. And my lords, my lady, can see that beginning at paragraph 43, it's under the heading convention, but just for your reference, perhaps for your note, if you go back to page 76, it's within the context of age discrimination. And so, as I'm sure you've elicited, we don't appeal the approach under EU law to age discrimination, but we do approach age discrimination with this appeal under the convention. And at paragraph 43 and onwards, the court below summarised the competing arguments on behalf of the parties. I'm perhaps standing in for Miss Rayner in this appeal now, but you can see that on behalf of the appellants, Miss Rayner had set out her case. Then there is reference at 46 to Sir James's submissions on age discrimination. And then the key conclusions, my lords, my lady, are really at paragraph 47 through to paragraph 55. And it's in those paragraphs of the judgment below that the reasoning is given for rejecting the argument that the changes in question were discriminatory on grounds of age, contrary to the convention. Broadly, as we say in our skeleton, they distill into two key findings. The first is to be found at paragraph 52, and that is that the court below held that there was no comparability, so there was no ability for the appellants, or the claimants as they then were, to compare themselves with women of a different age. And then secondly, at paragraphs 53 to 54, the court below held that even if there was any discrimination, justification was made out. And so as we say in our skeleton, beginning at paragraphs 11 and onwards, we seek to appeal both of those elements of the court below's reasoning. So we seek to appeal both the approach to non-comparability and to justification. And I'll take those issues in order, please, if I may. Dealing first with the court's approach to non-comparability, could I turn up another authority, please? It's at tab 49 in the authorities bundle, which I believe my lords will find, my lady will find within volume 3. And I believe that the authority of Clift at tab 49, I'm sorry, forgive me, at tab 51, maybe very front of your volume 4.
Sorry. You don't want to. Oh, no, it's not right. So
I'm so sorry. It's got, I think it's the beginning of your volume 4. Yes. It's tab 51.
Right.
And it's the case of Cliff.
One moment. Yes.
That should be the 2010 July decision in the case of Clift. And if I could ask you please to turn within that, it's a case against the UK, to internal paragraph 60, please, which should be at pagination bottom middle 1567. My lords, my lady, will see that there is discussion there within paragraph 60 of the proper approach to be taken to the question of comparability for the purposes of a direct, as we would call it, discrimination claim under Article 14. And within paragraph 60, about 6 lines down, my lords, my ladies should see this phrase, that the question whether there is a difference of treatment based on a personal or identifiable characteristic in any given case is a matter to be assessed taking into consideration all of the circumstances of the case and bearing in mind that the aim of the Convention is to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. And so that is the guiding principle we would submit in approaching questions of comparability. My lords, my lady, the principal basis on which the court below found that there was not comparability on grounds of age was the Strasbourg authority of Ackermann. And so could I ask you please to turn up tab 12 of the authorities bundle that will be within volume 1. It's a short admissibility decision within volume 1.
Sorry, and can you just talk, answer on this one, please? Paragraph 60 on Clift, is that statement of principle applicable to direct or to direct and indirect discrimination?
I think for our purposes, my lord, it's primarily around the question of status. And so when one is looking to see whether there has been, as the phrase used here is, a difference of treatment based on a personal or identifiable characteristic, the phrase difference in treatment there is more resonant of the direct discrimination approach. But if the court is being asked to assess particular facts, where there has been a policy that has, it is said, a disparate impact on a particular group identified by a characteristic, then it's likely that that principle would apply too.
Is your age discrimination case under Article 14, A1P1 and Article 14, based upon both the alternative direct and indirect?
No, forgive me, I should have made that clear. The age discrimination claim is put as one of direct discrimination, and that is why the focus of the judgment in the court below was a non-comparability issue, that it was said that there were not two groups who could properly be compared. One will see, my lord, when we come to the arguments on sex discrimination, that that is put as an indirect discrimination claim, and that when we come to look at the reasoning of the courts below on the sex discrimination point, that was within a framework of the impact of a policy. So one will see it's a different analysis. I should have made that clear, forgive me for not doing so.
No, not at all, I just wanted to make sure. Okay, so I'm so sorry. So where do we go after that? BA112?
It's Volume 1, Authority 12. And it's the case of Ackermann, which is significant, my lords, because that is the principal authority that was relied on by the court below.
Thank you.
And my lords will see, my lords, my lady will see that Ackermann is a short decision of the Strasbourg court. It is an admissibility decision. One can see that from the top of page 186. One can see that the facts, very briefly, are around a series of complaints to do with what was described as old age insurance.
Does the fact that it's an admissibility decision affect the weight that, or the ability to rely on it by this court?
My lady, our submission in the skeleton argument is that the reasoning given in this particular admissibility decision is very sparse. And so when I come to take you to the particular parts of Ackerman, you'll see, I would hope, that there is very limited consideration given to the comparability question. There may be other admissibility decisions that give a more fulsome treatment of the issue in question, but on these facts, we would submit, and we make clear in our skeleton argument, that the reasoning here, I think we say at our paragraph 18, page 18, paragraph 15, is very limited. So this particular decision, in short, my lady, has alighted on our point, was given undue preference, undue reliance, if you like, by the court below. Our broad point is that Ackerman cannot be read as standing for the proposition that is taken from it by both my learned friends and the court below. It is overstated and overinterpreted, if I can put it that way. My lords, my lady, will see the summary of the complaint in Ackerman begins, if one can go please to the foot of page 190, there is a heading, the law. And one can see there that the applicants complained under Article 1, Protocol 1, as we also do in conjunction with Article 14, about the obligation to contribute to the statutory old age insurance scheme. And they complained that this amounted to discrimination on grounds of their sex, their age, their birth, and their professional and social status as employees. They complained in particular about discrimination when compared to a group of self-employed persons and of civil servants with comparable income who were not subject to the obligatory pension scheme. They claimed that the obligatory insurance imposed on them the burden to finance benefits for society more widely, and complained about being burdened with that. Then you'll see this, they finally complained about discrimination due to their age, alleging that they were likely to receive a considerably lower pension when reaching retirement age than earlier generations did. The first applicant, who was unmarried, also complained about being discriminated when compared with married men. So just pausing there, my lords, my lady, can see that there were a series of complaints being made in Ackerman across a range of different grounds. One can see that the court then goes on to summarise some of the recognised principles. At the foot of page 191, one can see that the court reiterates the principle about 4 lines up from the bottom, that very weighty reasons would have to be put forward before the court could regard a difference of treatment based exclusively on the ground of sex as compatible with the convention. And I ask you just to note that, my lords, my lady, because that principle around weighty reasons for discrimination on the ground of sex is one that we will come back to. Over the page, one can see that throughout page 7, consideration is given to the series of complaints that were made by the applicants in Ackerman. But the only paragraph that really deals with the age discrimination complaint is on page 7. And I'm sorry that for some reason this has not been sidelined, my lords, my lady, it should have been. But if you can mark, please, from the top of page 7, it's about 6 lines down. And you can see, I hope, a paragraph that begins, insofar as the applicants further complained about discrimination on ground of age. You see that part? Alleging that earlier generations of pensioners received considerably higher pensions than they themselves would on reach pension age. The court notes the applicants have not established that their own situation is comparable to that of earlier pensioners. In this respect, it has to be taken into account that the state must be in a position to adapt the pension system to the change of socio-economic circumstances. Accordingly, the applicant cannot claim equal treatment in time. Just pausing there, my lords, my lady, it's that paragraph that was the basis on which Ackerman was relied on by my learned friends and by the court below. It's that particular paragraph to the effect that the applicant could not claim equal treatment in time. And our submission in relation to that, my lords, my lady, is that that is a very shortly reasoned decision. There is no clear reasoning given for the non-comparability finding. Much of this admissibility decision is focused on the other grounds of complaint. And in our submission, it cannot stand for the proposition that there can never be comparability on grounds of age in these circumstances. One can readily imagine where a scheme was designed that was discriminatory and where there was proper comparability. There is no clear reasoning for the phrase, the applicant cannot claim equal treatment in time. It is not clear at all what that means. That may mean nothing more than at one particular point in time, the applicant was not going to get the same pension as someone of a different age. And the reference, my lords, my ladies, to...
Surely, Ms Hill, the sentence starts with accordingly. It is simply drawing out the logic of the previous sentence, which is the state must be in a position to adapt the pension system to changes in socio-economic circumstances. So the reference to in time means that if there have been changes from time to time, you can't cross-refer between groups subject to separate regimes created by such change.
My lord, you're quite right to try to construe the paragraph in that way. The reference, though, to the proposition that the state must be able to make modifications to a particular pension system, in our submission goes more to justification, because it cannot be the case that this paragraph stands for the proposition that any alteration of a pension scheme by a statutory change does not generate not a comparability about which discrimination could be complained. I mean, one can well imagine a scheme that could be created that would be discriminatory and about which there would be two different groups that could be properly compared, where that discriminatory treatment felt to be justified. This paragraph in our submission cannot lead to the proposition that there is never comparability on grounds of age. And the other...
It's not saying then, it can't possibly be saying there's never comparability on the grounds of age. What it seems to be saying, or at least what the Divisional Court thought it was saying, was that where you're looking at a change in regime for pensions, an adaptation of the pension scheme, if that change is brought in and affects people, some people, but not other people, depending on the date chosen in the legislation, then that doesn't create a comparability group. I mean, wasn't there also a case about prison sentences which came to the same conclusion, that a change in the parole regime or something like that? Sorry, I'm casting round vaguely in my mind, which also held the same principle, that the legislation has a start date. People who fell within, or there was one about leasehold property as well, that if you are lucky enough to get whatever it is or be in a particular position before the legislation comes into effect, well, you're lucky, and people who for whom the circumstances arise after the legislation comes into effect are unlucky in a way, but they can't compare themselves with each other for the purposes of creating a discrimination group. Isn't this an aspect of that same principle?
Well, my lady is quite right, and I think, my lady, you had in mind, in particular on the prisoners issue, the case of Minter and the case of Zamet, which are the other two authorities referred to in the judgment below that I was about to take my lady to, because the totality of the authorities that were relied on by the court below are three authorities. The first is Ackerman, to which I've taken you to, and I don't propose to return to. And the other two are side by side in the authorities bundle, please, at tab 17 and 18, respectively, Zamet and Minter. Minter is the one that relates to offenders. That may be the one my lady had in mind. And Zamet is the one about property in particular. So these two authorities are around the issue of legislative change creating a line, which I think is what my lady had in mind. It's around who falls on the right or wrong side of a particular line.
Yes, thank you.
My understanding of your proposition is that while it may be the principle established by this case, that merely a difference in age, the age in itself, isn't an appropriate comparability, you nonetheless can prove, due to particular circumstances, that you are in fact in an exactly analogous position, combining age with other factors.
My lord, yes, that's right, because we argue both for age and sex together, but the proposition that in my submission one can draw from Zammit and Minter, those are both cases on completely different factual circumstances that don't relate to anything to do with age or one of the other protected characteristics. What Zammit and Minter are looking at in our submission is whether the fact that you are on one side of the line or another is itself a status or a characteristic about which you can complain of discrimination, which is very different, we would submit, to what we have here, which is where the line itself creates a distinction between people based on a protected characteristic or a combination thereof. So I'll perhaps just put that more clearly, if I may. Zammit, one can see, if one looks please at paragraph 17, at tab 17, was a case about a particular change in a property regime within Malta, and one can see by looking within that, please, to internal paragraph 69, it's on page 340, that the complaint under Article 14 in that case, one can see from the facts at paragraph 67, in fact, that the complaint was, the applicants complained that they had been treated differently from other property owners who'd only begun leasing their property after 1995 and who were therefore not subject to the restrictions arising from the ordinance. And the court went on to say that in the court's view at 69, there was no distinguishing criteria based on the personal status of the property owner, nor on any other ground. Paragraph 70, that no discrimination was disclosed as a result of a particular date being chosen for the commencement of a new legislative regime. Differential treatment arising out of legislative change is not discriminatory where it has the necessary justification. And that proposition was also adopted to similar effect in Minter, which is the case around the notification requirements for former offenders. And just briefly, if I may, one can see from internal paragraph 67 of Minter, that's the next case in the authorities bundle. So it's tab 18, it's internal paragraph 67, that the principle in Zammit was quoted in Minter. One can see towards the end of paragraph 67. And again, the principle is repeated that no discrimination was disclosed by a legislative regime that set up effectively particular categories of people based on a particular date. And we would submit, my lords, my lady, that the position is different, whereas here the legislative scheme is creating discrimination based on protected characteristics, whereas in Zammit and Minter the argument was that the scheme itself is what divided people into groups. Whereas here...
You've shown us that age is not a protected characteristic as such.
Forgive me, no, it's not protected on its face, but it's recognised as falling within the status within Article 14.
Then
And I should have taken you to the other principles in Carson that established that. I don't believe there's any dispute between us, my lord, between the parties, that gender is recognised on its face within Article 14, and age is recognised as falling within one of the understood other characteristics within Article 14.
well, I just want to be clear about this. Just for clear thinking, it may not ultimately matter. you've got a list of what we all call protected characteristics in Article 14, and then you've got other statuses about which there's been a lot of case law about what counts as a status and what doesn't.
Yes.
But are you saying that age is a sort of implicit protected characteristic, or are you saying age is a status?
I'm saying that if one looks at the wording of Article 14, although age is not explicitly mentioned within it, where at the end of the text of Article 14 there is reference to other status, it is understood that age falls within that as a status.
Yes, that's what I was putting. So,
could I give you a reference for that, my lord, to make that proposition good?
Well, do you then say that if it is an other status, it thereby becomes a protected characteristic as much as the ones expressly mentioned in Article 14? Or is there some difference in value? Or I'm not talking about the concentric circles point, but is there some difference between other statuses and expressly named characteristics?
There is one comes to the justification test, and there are some that are recognised as requiring particularly weighty types of justification. I don't believe that there is a difference in principle if they're within the text of 14, that there is any hierarchy beyond that. I should perhaps have taken you to not only Carson in Strasbourg, but Carson in the House of Lords. Perhaps for your reference, it's tab 27 of the authorities bundle, which does talk a little bit about the differences between those characteristics, but does make clear that age is recognised as being within the latter phrase within Article 14, and talks about that being a borderline case of whether or not it requires weighty reasons or not. But I think there's no dispute between us that age does fall within Article 14, but not on its face.
no, I understood that, but my thinking was along the lines that my lady just drew out from you, that if, apart from the point you referred to, which we aren't on at the moment, about the weight of justification required, if other status and the particular ones that are mentioned are all conceptually the same kind of thing, how does that fit into the way in which you're seeking to distinguish cases of the Zammit and Minter kind from the present kind? Because you're saying that those were only cases about whether it was a protected status. But isn't that, or more accurately perhaps, whether you can compare yourself with someone affected by a different regime? You're saying this is different because it's a protected status. Have I misunderstood your point?
No, you're quite right, my lord. The reason why Zammit and Minter are different, we submit, is because if one just looks back at the text of Zammit, paragraph 69, the question there was whether there was anything about the personal status of the individuals here. And the finding in Zammit was that there wasn't, because all there was a new legal regime. Whereas something like age is well recognised as being a personal status that falls within Article 14. And quite a few of these cases are about whether something does fall within Article 14 or not. And the arguments here were about the sort of things that might generate the ability to compare different groups, whereas age is recognised as being within Article 14 already. If you wanted the proposition for that, Carson...
No, I think I've got, and I now see your point. I think you misled, perhaps I wrote it down wrong, but you were saying that the distinction is that in this case the discrimination is based on age, which is a protected characteristic. To fit into the reasoning here, you should have said more with a personal status.
Forgive me, I'm sorry if that misled you.
No, I bottomed it out, thank you.
So are you saying that if in Zammit the legislation had said, henceforth all landlords below the age of 50 will have to pay this particular tax or whatever, then Mr. Zammit, as a 48-year-old or whatever, would not then be comparing himself simply with landlords that fell on the other side of the date line, but would be comparing himself, well, no, that doesn't really work, because then there would be landlords after the date when the legislation came into force who were also in a different position.
I think what I was hoping to illustrate is that if the scheme itself creates discrimination based on a personal status, such as age, then it will fall to be justified and may be capable of being justified. But in these cases, the court felt that the personal status element was not made out by the fact of the legal regime. And these cases, as far as I can understand them, did not involve any other personal status beyond the existence of the new legal regime. Whereas here, there are legal changes, but they create discrimination based on particular personal characteristics, either gender that's recognised on its face as within 14, or age which is recognised as implicitly within it.
But isn't that just arising from the fact that necessarily when you change a regime that is based and must be based on somebody reaching a particular age, that you're going to create a distinction between people based on their age? Isn't it inherent in the nature of the particular regime, which was not the same in Zammit and Minter, that any cut-off date, because of the introduction of the new regime, not of course acting retrospectively, is going to create a difference in age?
But my lady, this is solely focused on the court below's findings of non-comparability. So my argument would be that if you have the regime that my lady's just posited, that a new legal regime says everybody over 50, something happens to them, everybody under 50, this thing doesn't happen to them, then that's a legal regime creating two groups. But the difference between those people is their age. They're otherwise exactly comparable. And then the analysis would be whether that regime is justified. The point I'm trying to make here is that Zammit and Minter don't help on those comparability questions, and that the court below was wrong not to get to the justification issue. And it did eventually then deal with justification, and I'll come to that. But this is all focused. Perhaps I could just take you back briefly to the way in which the court below dealt with this, because the court below found that there was not comparability based on a combination of Ackerman, Zammit and Minter, and our submission it was wrong to do that. But it did then go on to deal with justification, and that's a separate challenge.
I think
all I was trying to illustrate is that Zammit and Minter are completely different, we'd submit, to the case that you have before you.
Well, I made a note of that submission, but I have to say I don't think I've clearly followed the argument, and it's important that I should do so. I certainly see the argument you're putting forward on Minter and Zammit, which, as I understand it, is that in those cases there was nothing other than, as it were, the date line for when the legislation came into force. There was nothing other than that which created anything by way of comparability that was appropriate, and so you have to go straight to justification. I think that's the point you're making on those two cases.
Yes.
That bit I understand, whether it's right or wrong doesn't matter, and that's clear enough. But I'm still slightly at sea on your point on Ackerman, because Ackerman, the reasoning in Ackerman was rather different, I think. So if you can go back to Ackerman.
It's tab 12, my lord.
Tab 12. I mean, what I thought you were saying on Ackerman, but I may be wrong, this is looking at the relevant paragraph on page 7 of the authority, is that they say the court notes that the applicants have not established that their own situation is comparable to that of earlier pensioners. But that presupposes there may be cases, I thought you were saying, where you can show that your own situation is comparable to that of earlier pensioners. In other words, you can adduce additional facts. But have I misunderstood that?
No, my lord has understood. The point I make about Ackerman is that the extent of the reasoning on the comparability question in Ackerman is those 2 or 3 sentences that one finds here. And it is saying that in this particular case,
Yes.
for reasons that the court found there was not comparability, that on these particular facts the state must be able to adapt pension systems, but that doesn't mean that there can never be comparability between people on grounds of age, and that the combination of this and Zammit and Minter meant we submit that the court erred in finding that there was not comparability. It should have found that there was comparability between the appellants and women of a different age, and then dealt with justification.
Yes, so as I understand it, I understand that proposition, and so your argument would have to have been, perhaps it was, before the Divisional Court, that the people in your particular cohort, the claimants, are in an identical position to either the earlier, what Mr. Mansfield described as category B or category A, or indeed even those of an earlier period than April, I think it was 1950. I mean, that's your point, that you were in a comparable position
Yes.
to those people, and the court, you say, should have gone on and considered that point.
Yes, so my lord, we've made submissions that perhaps might assist make that good a little further by drawing analogies with what the domestic law approach to comparability would be. And those submissions, perhaps just I can assist by asking you to look at paragraph 13 of our skeleton. It's at page 17.
All right, but has what I said reflected correctly the analysis that you're putting forward?
Yes, that there should have been a finding of comparability.
That the judge, in this case, Minter and Zammit don't apply, because there nothing was relied upon other, as it were, than the simple fact of the point at which the relevant new provisions come in. But in your case, you say, unlike the Ackerman case, you were adducing evidence to show that in fact you were in a comparable, or more comparable position, I don't know, comparable position to those of an earlier birth.
And where the court below found at paragraph 52 that Ackerman was close on its facts and that it suggested that Article 14 was not even engaged, that's where we say the court below went wrong in this part of the analysis. Right. And it is, in fairness, my lords, my lady, it is only one part of the court below's reasoning. It does go on to deal with justification. But my lords, my lady, can see at paragraph 52 of the court below's judgment, it's at page 81, that essentially they said that if that is correct, then they need not consider justification. They did nevertheless go on to deal with that.
But what are the facts that you say make you a different case from Ackerman on this direct age discrimination? What are the features of the regime or the features of this cohort that you say mean that they are different from what Ackerman seems to have reasoned?
The closest analogy, perhaps, is to take you, if I may, to MacLeod. I mean, that is a very comparable case, and perhaps assist with the understanding here. And just very briefly, if I may, could I ask you to look at the skeleton at paragraph 11 on page 17 of the core bundle? Because in our submission, that is a much closer analogy than one finds in Ackerman. My lords, my lady, can see, it's at page 17, paragraph 11, that essentially, as we set out at paragraph 11, there are three categories determined by age, as Mr. Mansfield set out. So the age is the distinguishing feature between these three groups. And that is very similar, we would submit, to the approach the Court of Appeal took in MacLeod, where, again, there was a scheme that had been set up, and the Court had no difficulty in putting the individuals within that scheme into three different groups as it happened. So paragraph 13 of the skeleton, we made clear that what happened in MacLeod was a decision that there were three groups and there was treatment that was less favourable as between A and B, as between those in B, A, B and C. So essentially there was a sliding scale of less favourable treatment, and the Court had no difficulty in finding that the date of birth was the distinguishing feature, and that's a much more similar set of facts, we would say, to what we have here, and much more consistent with the approach that the Court should have taken, because although MacLeod was dealt with under the Equality Act, the test there is simply, are there comparable groups that have been treated less favourably? And the Court of Appeal held that there were different groups defined by their age, and there was no difficulty with the Court holding that there had been comparability, and indeed that there'd been discriminatory treatment of them. And my lords, my lady, a more recent example that may assist you is at the very back of the authorities bundle, the case of Hughes. I don't know if it would help just to look at that very briefly, if I may. That authority, you'll find it, I think, within the final authorities bundle at tab 60. Could I ask you to look, please, at tab 60? One can see, just very briefly from the first paragraph, this was a case around decisions to do with a particular pension scheme, decisions about how the pension scheme was going to operate, I think, in the scenario where some of the employer became insolvent. And if one goes through the judgment, please, to page 1, internal 1830, paragraph 85, one can see that here Mr. Justice Lewis was dealing with very similar arguments to what one has here. Paragraph 85 makes clear that he was dealing with, is there discrimination on grounds of age, contrary to EU law or the convention? And one can see, if one goes through the judgment, please, to page 117, under the question, do the statutory provisions involve differential treatment on grounds of age between persons in a materially similar position? The learned judge said that his conclusions on this issue can be stated shortly.
I'm so sorry, I got lost for a moment. Where have we gone after paragraph 85?
I'm so sorry, my lord. It's 117 under the heading, is there comparability?
Yep.
Is there different treatment on grounds of age between people in a materially similar position? And the learned judge held that the compensation cap did involve, he said, differential treatment on grounds of age. Those who were above the NPA, which had been fixed by reference to an age, did not have the cap applied to them. The differential treatment does apply to those in materially similar provisions. A person in a particular scheme with pensionable service yielding benefits above the level of the compensation cap does not have the cap applied if he or she has attained NPA on the date when the scheme enters assessment. It goes on. I mean, the main point of this, my lords and my ladies, is that persons in materially similar positions are therefore treated differently on grounds of age. And
so I think what you're saying is that the difficulty arises here not between comparing people with the position of others before the relevant pension acts came into effect. What you're doing is comparing this cohort with a different cohort after the pension acts have come into effect, because the regime which is set up by the pension acts, once they have been brought into force, is a regime which differentiates the entitlement of people to a pension on the basis of their age. And so here we're not talking about the cut-off dates to do with the commencement of the legislation, but the date set for entitlement to a pension once the regime is brought into force. Would that be a summary of the difference that you're looking
Yes, my lady. And that on these facts we're much closer to the analysis in MacLeod and in Hughes, that they are much more analogous scenarios, and that the findings in those cases of comparability should have been made here. And those are all the submissions I wish to make on the comparability point. Unless there's anything in particular on that I can assist you with further, I'll perhaps just give you one further reference, if I may, which is the case of DA, which you'll have in your bundle at tab 45, just to make the note perhaps that within that case at paragraph 46, there was a similar finding of comparability without difficulty on facts that are, we would say, more comparable to these facts than to Ackerman. But perhaps I can...
Case was that again?
It's the case of DA, be the Secretary of State for Work and Pensions. It's at tab 45, and within that authority, there was a finding that the appellants, 3 single mothers and 3 of their children, who were affected by the benefit cap, could compare themselves to others to whom the cap applied. So it's just a similar finding on comparability. So it's at page 1355, paragraph 46.
I don't recall that in Hughes there was any reference to Ackerman.
I don't believe so, my lord.
Well, was there any reference to Ackerman in any of the other cases you referred us to?
I don't recollect it being quoted in MacLeod, but I'd have to check. But I don't recollect it being dealt with in any detail. Just bear with me a second, please. I'm looking in the All England report of MacLeod, my lords, at page 1166 of the cases referred to, and I don't see that Ackerman is listed. We only have the unreported version of Hughes, but I don't recollect Ackerman being dealt with.
Right.
So, my lords, if I may, could I move please to our further submissions in relation to age discrimination? Perhaps just to orientate you in our skeleton, these are at internal page 16 of the core bundle, and they are not only around the comparability finding, but around the justification finding. So if one turns please to paragraph 16 of our skeleton, it's at page 18. Could I ask you to turn that up, please? It's page 18, paragraph 16. And my lords, my lady, can see that at paragraph 16, we've made the second submission that we make under the age discrimination heading, and that is to the effect that the court below erred in its approach to justification, because the principle set out by Lord Wilson in DA, at paragraph 53, was that what is required in this scenario is not only an explanation for why a particular scheme has been brought in, but why a particular scheme has been brought in that has disproportionately adverse effects, that is the focus of the justification analysis. And on these facts, the evidence before the court below, perhaps I'll just give you the reference, if I may, please, my lords, my lady, but there was evidence in the court below from Ms. Willis-Stewart that begins at paragraph 257 about the substantial disadvantage caused to women within the cohort group of the sort amplified by Mr. Mansfield in opening. So the court below had evidence before it that this was a scheme that created a substantial disadvantage to women.
Oh, well, hang on. Do you mean that? That doesn't help you at all, say it's a scheme that produces substantial disadvantage to women. Surely what you've got to say is it was a scheme which produced a substantially disproportionate effect, adverse effect, as between one defined age cohort and an otherwise comparable defined age cohort.
Forgive me, the evidence was focused on the impact that these changes caused on this cohort of women, and went through a series
I
of...
know what your proposition is first, and then you can tell us how the evidence supports it. What is the proposition?
The proposition is that the court below had evidence before it of substantial disadvantage caused to women.
Okay, hang on a second. That's what I thought you said. Had evidence of a substantial disadvantage caused to women
By the equalisation of the state pension age.
But here we're dealing with age discrimination, aren't we? Not sex discrimination.
The evidence that was placed before the court below dealt with the particular impact on this group of women. And
well, that's what you said. That's what I was trying to pin you down on. First of all, you said women, and then when I challenged you, you said this group of women. But then you went back and asked you what the proposition is. You said it was simply caused to women.
Forgive me, I was reading out the introduction to Ms. Willis-Stewart's evidence. My understanding is it deals with, if, as we say at paragraph 17, it goes into the disproportionate adverse effect on women born in the 1950s on these women. And it goes through all the data around employment, around income, and so on.
Yeah, now when you say disproportionately, in proportion, as compared with who?
It focuses on, for example, the issues caused by patterns of employment around these particular ages. So it looks at a combination of gender and age, as far as I read the evidence.
As compared with who? Disproportionate must mean affecting this group more than which group?
It's older women is what it looks at. So it looks at the combined effect of age and gender on this particular cohort.
Yes, but you must be comparing them now, not with the group, the category A, which is the group who are not affected by the pension changes and still get their pension at 60. But you must, in this context, be comparing them with younger women who are born, say, in 1980, because I think the thrust of your case is, broadly, that they should have only applied the increase in pension age to younger women who have a greater chance of having a better paid, longer full-time employment career. So you must be comparing them then not with the older women who are not disadvantaged because they're not affected by the pension change, but with younger women who are affected but who can bear the change better because of their better employment record. Isn't that right?
It was looking primarily at the impact on older women of these changes, in particular compared to men.
Well,
yes, but you're I'm sorry.
On that part of the case.
I'm sorry, your comparator group, I mean, what has to be justified, presumably, is the discrimination in relation to the comparator group. Am I wrong about that? That must be the process.
No, that's right, and
right.
we are...
So, hang on, so the comparator group I thought you were talking about are category A people.
When one is looking at age alone, we of course are arguing under Article 14 a combination of gender and age. For the purposes of this point, this isn't the age discrimination element is looked at firstly as age alone, but also as age combined with gender.
All right, but can we just take age alone, just for the moment, just simplification, because I may be wrong about this, but on age alone, you say the comparator group is what Mr. Mansfield and your appellant and the skeleton argument describes as the A category.
Yes.
Right. So if you're seeking justification, what has to be justified is the discrimination or the adverse effect vis-a-vis that group, surely.
Yes.
But that's not what you're relying on.
I'm drawing out for you the fact that in the court below there was evidence placed before it of the sort I've described, because that affects both the age and the sex discrimination
Well, does it
argument.
affect the age? Are you saying that the 1950s cohort were in a worse, if I can just summarise, economic position, socio-economic position, than their older peers, than older women born in the 1940s? Seems counterintuitive. I don't think that's what Willis Stewart was intending to achieve, intending to show.
No, my lord is right. The point I'm making is that Sorry.
You go ahead.
No, go ahead.
Well, all I was going to say is, if my lord is right, and I think I understood you to accept him, that for the age alone comparison, you're comparing with the A group, that can't be on the basis that there's evidence that the B group socio-economic position was worse than that of the A group.
That's right, my lord. That's right.
What is it based on?
The only point I'm making for these purposes is to draw out that there was nuanced evidence before the court below around the impact on this particular group. It only assists to some degree, I recognise, on this particular ground. It may assist me more on the sex ground, but we do advance the complaint based on gender and age combined. And what is, I would submit on behalf of the appellants, noticeable is that the evidence advanced by the Secretary of State below seemed not to accept the impact on this cohort of women. And so the evidence below around...
Sorry to keep interrupting you. What do you mean did not accept the impact on this group? Obviously this group of women are impacted, but you mean the disproportionate impact?
Yes, and so...
And we're trying to pin you down on disproportionate compared with whom? And in what way?
The combined effect of gender and age on this cohort is what has created the particular disadvantage to them, combined with the lack of notice. The point I'm simply making for these purposes is that when the court below came to deal with justification, it had before it a perhaps unusual situation where there was evidence being put forward by the appellants of particular adverse impact. There was evidence being put forward by the Secretary of State, but that evidence, as far as I read it, did not appear to say we accept these impacts, but we justify them in these particular ways, and that what the court below should have done was ensured it was satisfied of what is set out in DA, that there is a disproportionately adversely discriminatory scheme, but it is nevertheless justified.
Could I just ask this? If you read this part of your skeleton, which is really just 2 paragraphs, you are making a single point, which is the one you're now making.
Yes.
Which is that the Divisional Court asked itself the wrong question. It didn't ask itself the Lord Wilson and DA question. It asked itself a different question.
Yes.
The logic of that is the case would have to go back to the Divisional Court to be decided on the right approach. Is that right?
My lord, I would accept that, and it may be that my reference to the underlying evidence has muddied matters, and my apologies if it has. Our point in the skeleton, my lord, is quite right, is the one that is set out at 16 and 17, that the DA question is not what the court below asked when looking at justification on grounds of age.
There's no alternative challenge on the basis that if it was asked itself the right question, it was wrong to reach the conclusion it did on justification. Have I put that clumsily?
Forgive me, my lord. Could my lord repeat the proposition? I'm sorry.
You're not running an alternative case that if the Divisional Court asked itself the right question, it nevertheless reached, I'll put it the other way around, if the question which the Divisional Court asked itself was the right one, it was not entitled to reach the conclusion it did on justification. I still put that clumsily.
No, I'm sorry, it must be me. I think all I can say, my lord, is that the ground is argued quite broadly in the grounds of appeal. It's simply that the court below was wrong to find that there was justification. The way it's developed in the skeleton is to say that it was wrong because it asked itself the wrong test.
Okay, well, I think that's clear enough.
And all I've perhaps done is just highlighted for you that there was a factual dispute below that would need to be addressed if my lords and my lady were persuaded that the court had in fact erred in justification on grounds of age.
The factual dispute from Mr. Gilchrist's evidence, what his evidence was directed at, is that it's not necessarily true. He wasn't going so far to say it wasn't true, but he said it was more complicated than one might think to propose that women born in the 1950s are generally worse off than women born in the 1980s, because he took it to mean that that was the disproportionality of the effect, that it was disproportionate to increase the pension age for women born in the 1950s rather than, say, just women born from 1980 onwards, because it was not the case, you say, that those two age groups are in a comparable position. Mr. Gilchrist says, well, it's more complicated because women in the 1980s can't get on the property ladder and they have defined contribution pension schemes rather than defined benefit pension schemes and so forth. So he says it's a more complex picture. But there is, I think, still this mismatch between you're comparing yourself with for the purpose of finding the difference in treatment, and the group you're comparing yourself with as regards the disproportionality of effect, because the comparator group is the women who are able to claim their pensions at 60, who I think you accept are in the same economic position as the women born in the 1950s. But the disproportionality of effect, I accept what you say, it's a comparison with men as well, but insofar as it's a comparison with age, it's a comparison with a younger group of women who, say, are better able to bear the burden of the delay in the receipt of their pension.
My lady, yes. And the only other legal point I'd perhaps made just on this element, and then I think that will conclude my submissions on age discrimination, is simply that there is no difficulty between my learned friends and our team on the approach here. So as far as age is concerned, if it's age alone, we would accept that it is the manifestly without reasonable foundation test. But we would say, in relation to that nevertheless, Langford makes clear that there still needs to be a purposive or proactive examination by the court of that question. And we would still submit that the analysis of the court below falls short of what's required. So it's both by DA, and perhaps I could just give your lordships, my lady, a note. The Langford case at tab 46 is, as I'm sure that the court is familiar, perhaps just I could turn that up very briefly, please. It's within tab 46, which I think you'll find, I think it's within tab 4, just bear with me a second, volume 4. Just bear with me a second, please.
No, it's 3.
Volume 3, forgive me. The end.
Well, if it's so sorry, it is in bundle 3, but not towards the end. Yeah.
Forgive me, it's tab 46, and it's the Langford case that we've sidelined, please, just for the court, paragraph 50, through to 56, which you'll find at internal page 1413. And Court of Appeal or Justice McLean's judgment, beginning at paragraph 50, quotes back to Lord Wilson and how the manifesting without reasonable foundation test is to be applied in practice. There's a quote at paragraph 50 there about the need to proactively examine whether the foundation is reasonable. And then it's summarised, I think, at the end of this passage, paragraph 56, that the court says here, we must look at the reasons put forward on behalf of the Minister for the difference in treatment, start from the basis that unless it's shown that it's without reasonable foundation, then justification is established. However, we are to examine proactively whether the foundation is reasonable, and if we're not persuaded that it is reasonable, it will be fanciful to conclude that it's nonetheless not manifestly unreasonable. So that gives some further guidance as to the approach to justification that the court below in our submission should have taken. And we have also made the point in our skeleton, and just finally on this, my lords, my lady, that the observations of the UN Committee on the elimination of discrimination against women were before the court below. For my lords, my ladies, note at tab 57, there is the 2019 report from that committee that specifically references the socio-economic impact of the change in state pension age for this group of women of this age. That's paragraph 51 of the CEDAW report. And we have relied on the proposition to be taken from the QSA or A case at tab 58, that should have been taken into account by the court below. Paragraph 23 of that judgment at tab 58.
Sorry, paragraph, which judgment are we now talking about?
Forgive me, it's referred to as QSA, but the head note actually has it as A. It's at tab 58.
Okay, thank you.
And at paragraph 23, internal page 1743, there is reference there to the regard to be had to the CEDAW committee, and paragraph 23 says the recommendations of CEDAW express a point of view which is entitled to respect, and you've been provided, as the court below were, with the CEDAW observations that are at tab 57, and in turn paragraph 51 of those observations talk about the increase in state pension age and the impact on women. Perhaps I could just refer the court to the final sentence of paragraph 51. The committee is further concerned that the increase in the state pension age for women from 60 to 66 has affected the pension entitlements of women born in the 1950s and is contributing to poverty, homelessness and financial hardships among the affected women. So those factors as drawn out by the CEDAW committee, we argue should have been taken into account by the court. My lords, my lady, those are my submissions on the age discrimination ground. Unless I can assist you further, I see the time, and I wondered if the court wished to have a short break, but I'm content to proceed if you wish. I'm in the court's hands.
Well, I think we shall continue up until lunch, but let's think this afternoon whether we'll have a short break this afternoon.
I'm grateful.
Because I think if we're going to have a short break now, it's a very short time until 1 o'clock. So I think let's carry on to 1 o'clock.
Well, my lord, I'll certainly be finished my submissions before lunch, so I hope that assists. Could I ask you then, please, my lords, my lady, to look at our skeleton where we turn to the issue of the sex discrimination grounds. And as I've indicated, my learned friend Mr. Straw will take the EU point, and so our submissions on the convention, and insofar as that applies to the sex ground, begin at paragraph 44 of our skeleton. It's an internal page 25 of the core bundle. And we broadly set out there, firstly, the way in which the court below dealt with the issue of the pool, because this is an indirect discrimination on grounds of sex claim. And you'll see the heading, the pool for comparison. Just to orientate you over the page, little 3, the court below then looked at the issue of traditions and cultural norms. So that's a separate part of our challenge. And then finally, the heading on page 27 about the manifestly without reasonable foundation test. So, my lords, my lady, there are 3 parts to our sex discrimination argument under the Convention. And I'll just take them in order, if I may. So, turning first to the pool issue, if I could ask you to turn, please, to the judgment in the court below. My lords and my lady will see that that begins at paragraph 67 in the court below, page 84 of the core bundle. And again, one can see that the heading is the Convention, but this is under the wider heading in relation to sex discrimination that begins on page 81. And the court narrates some of the arguments that were made by the competing parties. The reasoning of the court, though, really begins at paragraph 72. And the court quotes the Essop case, which you have in the bundle, and then says at the foot of page 85 that Essop suggests that indirect discrimination occurs where there is a measure which applies indiscriminately to all, which causes particular disadvantage to a group or an individual, and in circumstances where the measure and its discriminatory effect is unjustified. And then the court goes on to say that it considers that the claimant's arguments fail or face difficulties on each of those three aspects. The court deals with the pool issue at the end of paragraph 72 by saying that the legislation is not a neutral measure but is targeted at those women who historically enjoyed an advantage based on their gender. And in our skeleton, perhaps I can just take you back to that, my lords and my lady, we submit that that approach to the pool question was an incorrect one. And perhaps I can just ask you to turn up, please, our skeleton in page 25 of the core bundle, where we have quoted the provisions discussed in Essop, and the point that is made there that not every member of the group needs to share the relevant protected characteristic to define who is in the pool for comparison. As we say at paragraph 46, goes on to say that the pool should be that which suitably tests the discrimination complained of, should consist of the group which the PCP affects or would affect either positively or negatively. And the pool that we contend for, my lords and my ladies, is that set out at paragraph 47, that the equalisation in the pension age affects women aged 60 to 66. And so the appropriate pool to test that discrimination is the women it affects and the men it would affect aged 60 to 66. And within that group, there is particular disadvantage. And that approach we would submit is similar to the approach taken by the Strasbourg court in JD. And I think, my lords and my lady, I've already taken you to that paragraph, but JD is within your bundle at tab 19, and at paragraph 89 I took you to that definition of indirect discrimination given by the Strasbourg court, and it talked about looking at the general policy or measure which has a disproportionately prejudicial effect on a particular group, even if it's not specifically aimed at that group.
But I mean, I've got a slight conceptual difficulty here, so I'd like you to help me with this. I can see that if you're setting up a scheme or changing something so that the position of both the men and the women is different from what it was before, that the PCP approach is a correct one. But the difficulty here is that the men, their position is not being changed. In relation to the cohort 60 to 66, 60 to 66, let's ignore the 66 for the moment, let's just take the 1995 Act. The fact is that the equalisation of women compared to the men doesn't affect the men at all. I mean, it is a discriminatory, deliberately, directly discriminatory matter, just affecting the women. And so taking a cohort of men and women together for the, let's say, 60 to 65 doesn't make sense. And that's why, I may have got this completely wrong, and no doubt Sir James will tell me I've completely misunderstood it, but I think I thought that is why the respondent's position is this isn't indirect discrimination at all. If anything, it's direct discrimination.
Well, My Lord, we put the case differently. We have put this as an indirect claim. We have put it on the basis that the pool is sufficiently drawn to include those directly affected by it, and that ESSEP supports the proposition that not everybody in that group needs to be necessarily affected by it. So we do advance a pool based on the men and the women.
Okay, so your pool then is men and women aged between 60 and 65. And the point about it doesn't have to affect everyone is, yes, there are a lot of rich women in that pool, and there are quite a lot of poor men. And the poor men may struggle because they don't have a pension between the age of 60 and 65, and there may be rich women who are not relying on their pension at all, the state pension at all. But you say that doesn't detract from the fact that actually the proportion of women who are poor and badly affected by not having a pension between those years is higher than the proportion of men who are affected. And it doesn't matter that there are some poor men and some rich women. You have to look at the overall proportions.
Yes.
So that I understand, but I struggle, as I think the Master of the Rolls struggles with saying, but the pool is not the pool of people affected by this legislation, because the men have always been deprived, if I can put it like that, of a pension between the ages of 60 and 65. But you still say that the pool is both men and women in that age group. Some of more women in that age group are adversely affected. Is that how you
For the purposes of the sex discrimination claim, yes, because it is the disparate impact on women and women of a certain age, because we do rely on both of the elements of Article 14.
No impact on the men. It can't be a disparate impact. There is no impact
Yes.
on this measure. So how is it a disparate impact?
It is the disparate impact on the women, even if there is no impact on
Disparate
the men.
means different for women than from men.
Yes.
So the whole point of discrimination is you have a measure which affects both men and women, but affects women more. That's the disparate bit. Here, this measure is not aimed at men at all. The measure is aimed entirely at women. So you can't ask what is the impact of the measure on the men. It has no impact on the men. So there can't be a disparate impact on the men.
But all of the impact on this analysis falls on the women.
Exactly. There is no impact on the men, so where's the disparate impact?
Well, there is nevertheless, for Strasbourg purposes, particular discrimination on the women, even if it isn't aimed at them, and this particular measure was aimed at them, it puts those women at a disadvantage.
Well, it's not a disadvantage compared with men. But the men have always been, as my lady says, the men have always been at this disadvantage. They've never had a pension between 60 and 65.
Well, our claim is put on the basis that the way in which the scheme was implemented and the nature of the changes has had a particularly adverse effect on this group of older women, women of a certain age.
Well, let's go back to age.
Well, it is just important, I think, perhaps to appreciate that our claim has been, although it's been dealt with separately by the court under age and sex ground, has always been put on the impact on this particular group of women of a certain age. And that is permissible in Strasbourg jurisprudence, and that is how the Article 14 claim has been put. And that if one just perhaps looks on in the reasoning at 73 of the court below's judgment at page 86, the court below goes on to look at the cultural norms or traditions that have been, it is said, in place, and goes on to conclude that that is a reason why there is not discrimination made out. And my lady will see paragraph 73 refers to these historic differences.
So I'm now moving on to your second point.
Yes, if I may please, my lord.
Yeah, fine.
And our skeleton has made clear, we've quoted in our skeleton, perhaps just, if my lady could just keep a hand in page 86, paragraph 73, and look at page 26, paragraph 50, we've quoted there in full the approach of the Supreme Court in ESSEP that talked about these contextual factors and understood that reasons why one group may find it harder to comply with a particular PCP could be social, could be traditional. All of those sort of factors are the ones that are in play here. And our submission is that it is often the nature of indirect discrimination that there are these contextual factors, and that is not a reason to find that there was no discrimination, which seems to be the logic of what the court is saying here.
Anyway, I don't personally have a problem at all with the proposition that you can combine sex and age in the way that you're putting forward. I mean, I don't have any difficulty in principle with that and identifying this particular group by virtue of both. But the whole analysis, I'm right in thinking, depends upon your first step of identifying the pool. You have to identify the pool because it's in relation to that pool that you have to find the indirect discrimination. That's right, isn't it? That's the critical first step.
Yes, I mean, the pool phrasing, if I can put it that way, comes perhaps more from our domestic discrimination approach. If one's looking at a Strasbourg approach, it's a similar analysis, although I don't think the phrasing is quite the same. One is looking in the Strasbourg case law for a general policy or measure which has disproportionately prejudicial effects. So one does have to look at who that applies to,
yes.
But JD describes a general policy or measure which has disproportionately prejudicial effects on a particular group. And here we say the particular group is the women of a certain age. And so one does need to look at the nature of the policy or measure, of course.
Yes, but it does depend upon a comparison between men and women of the same age group. That's an essential first step for you.
When one is looking at gender alone, yes.
Well, when one's looking at gender, when one's looking at gender, well, no, I don't, well, yeah, yes. Your starting point is, and I'm going to use the analogy of the pool because it's just easier to use it that way. The starting point has to be that you've got men and women of the same age bracket, whether it's 60, 65, 60, 66, I don't think it really matters very much. And then you say, once you've got that, yes, the common factor here is a retirement age of 65 or 66, but you say there's a disproportionate impact on women of this particular age. That's the second step. That's the logical progression of your analysis.
Yes.
And thank you.
Yes.
But what you're doing here is you are disassociating the disadvantage from the way that the measure itself operates. It's not that the measure operates disproportionately on women compared with men. It's that the outcome of the application of the measure is different. But is that a difference between Article 14 and the domestic law, or are you not saying that?
I'm not sure I follow my lady's question. Could I?
It goes back to how do you get over the fact that the measure is not an apparently neutral measure, which in fact we see is more difficult for women, for example, to fulfill. It's not a criterion that it's more difficult for women to fulfill than men, despite the fact that it apparently applies equally. That's not this kind of case.
No.
What you're saying is that the disadvantage that's described in the case law is not necessarily a disadvantage in it being more difficult to meet a particular criterion or test or threshold. It's just a general disadvantage of being poorer.
I think I can't do perhaps any better than just ask you to look again at the particular passage in JD, the Strasbourg Authority. I think we are all
to a disadvantage.
Yes. Yeah. I mean, if I could just ask you to turn it up, it's in the authorities bundles, and it's probably a good authority to have open anyway, because you'll need that, perhaps, my lords, my lady, for the final part of my submissions on this. It's tab 19, JD, and I think you've been already to paragraph 85.
Right, which paragraph?
It's paragraph 85 within JD, page 382,
Yes.
and paragraph 85 comes at the end of another series of propositions where the court is going through the different types of discrimination that it considers, and at 85 the court says simply this, that a policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, regardless of whether the policy or measure is specifically aimed at that group. So I think that's the perhaps clearest definition from the Strasbourg court. We are, of course, I'm sure, all familiar with provision, criterion or practice, can comply, can't comply, pools. Those, of course, come from our domestic language, but the clearest exposition is perhaps what I've put before you from Strasbourg. And so...
Is the logic of your position that, in a sense, the fact that a change is being introduced isn't, in fact, the essence of it? Suppose it were the position that it had always been the case from the start that men and women did not get pensions till 65, but you could show that the absence of a pension between 60 and 65 was worse for women than for men, because women are poorer and have had fewer, particularly in that era, fewer employment opportunities. So a challenge could be brought on that situation. Say you should have a pension scheme which introduces pensions earlier for women to reflect the disadvantages they've been at the labour market all their lives.
Yes, I think
that must be the logic of your position, mustn't it? In a sense, it's a logical accident that's been triggered by a change to produce equality, to produce nominal equality, rather than there having been nominal equality from the start.
I think the basic proposition is that if the state is going to provide any pension scheme, it has to do so in a non-discriminatory way throughout. And I think my lordship's question is based on that proposition, is it not? That there isn't a challenge based on Article 1, Protocol 1 simpliciter. There isn't a challenge based on the right to a particular pension at a particular time across the contracting states. It's more about whether, if the state chooses to make pension provision, it must do so fairly.
Certainly, and non-discriminatorily.
Yes.
But the point I'm putting to you is that if it is the case that women can be shown for socio-economic reasons, the sorts of reasons identified by Lady Hale in Ether, to need pensions more between 60 and 65 than men do, then the state is acting discriminatorily in not giving women pensions earlier than men, because they need it more for reasons to do with their gender.
Well, it will depend, will it not, on the strength of the evidence that merits the justification. And
yeah, well, I understand that, but your case is that there was strong evidence, which you say that the government didn't take account of, that women are in a worse socio-economic position, perhaps generally, but particularly, because this is what your case is about, in the years between 60 and 65, than men.
Yes.
So doesn't it follow that, suppose the pension ages had always been 65 for both, you would have, in principle, a good challenge to the fact that you haven't been granted a pension
Well, if that was what the evidence merited and the justification threshold was met for that disparate treatment, then that would follow.
Yes, and in a sense that is what you say the evidence does show.
For this group of women of this age,
Yes.
looking at the changes and the way that they're implemented, yes.
But that's a test which shows it's a thought experiment which shows, which we might say, shows that your complaint is not really about the effects of this legislation at all. Your complaint is that we have a society in which women have fewer opportunities than men, or at any rate in that period, for this group of women, that was the case.
Our complaint about the way in which the court below has dealt with those societal issues is that it is not correct to regard, we say, based on ESSA, the fact that there are those societal issues there as a reason for not also finding that this scheme has created unfairness and discrimination. So where...
I think the court was making the point that I've just made to you, perhaps not in exactly the words I would have made it, but that your real complaint is not about the effect of this or that pension scheme, but your real complaint is about the fact that women are socially and economically disadvantaged in society. And you're saying, because of that, you should have a pension scheme that benefits women as against men.
Well, at the end of paragraph 73, the court below says that the differential in the pension aid may have provided a form of mitigation for that pre-existing inequality, but its removal does not amount to discrimination because it does not cause the disadvantages or exacerbate them. They are there anyway. So it's recognising, yes, I think, my Lordship's point that there may well be, and there almost certainly are, societal factors here in play. But the point we make about that is that many of those factors are present, or similar factors are present in other forms of discrimination, other types of discrimination complaint. And that doesn't mean that these particular provisions have not themselves been discriminatory.
What is also then the problem with the regime is that it's not a means-tested benefit. It's a benefit that applies to everyone, and old age is used as an imperfect proxy for needing some more money. It's not a benefit. It's unlike pension credit. It's not a means-tested benefit. Everybody gets it, rich or poor, and in fact, you can get more if you're richer in the sense that you've likely made more contributions over the years and therefore are more likely to get the maximum pension than the minimum. But isn't it of the nature of a non-means tested across the board benefit that taking it away will adversely affect people who are depending on it more than people who are not depending on it for their daily bread?
Well, that may well be right, lady, but of course our claim is focused on the impact on women of a certain age. And that's what the evidence was focused on. So our submission remains that the court below erred in the way that it looked at these societal factors. And while perhaps just going to make my final submission on the sex discrimination complaint, while one is looking at JD, the key part that we also draw from JD, if my lords, my lady still has this open, is at paragraph 89, which is where the Strasbourg court goes on to reiterate in JD that where one is outside the context of transitional measures designed to correct historic inequality, and pausing there, our submission is that we are outside that criteria because that is not the proper way of looking at the history here. The proper way of looking at the history here is not that there's been an injustice against men by the disparate pension age, but that this change has been to compensate women for the disadvantages they've suffered by working less and earning less over time. So our submission is that one can put aside the beginning part of paragraph 89 and then say this, that the court has held that given the need to prevent discrimination against people with disabilities, and it goes on to say, for that group, there is a need for very weighty reasons to be advanced for discrimination. The same is then true, it said, of gender equality. Very weighty reasons would have to be put forward before a difference of treatment would be regarded as compatible with the convention. And this brings me, if I may, to the final dispute perhaps between Malone and Friends and our team around the nature of the justification test. My lords and my lady will see that at the end of paragraph 89, the Strasbourg Court quotes the Konstantin-Markin case as another authority around the proposition that very weighty reasons are required for gender-based discrimination. And my lords, my lady, has in the bundle, towards the back of the authorities bundle, please, it's tab 55. I could ask you to find that within authorities bundle volume 4. I could ask you to turn it, please, tab 55. Tab 55, another Strasbourg decision in the case of Room 2 in Cyprus. And the reason I have placed that for you is because this again quotes the principle set out in Markin. If I can ask you to look, please, at paragraph 74. 74 and 75 of this judgment quote the Markin case as determining that where there is a question of difference in treatment on grounds of sex, the general principles which apply in determining the question of justification were restated in that case. And going over the page, about 7 lines down from the top on page 1690, please, that in this decision, the advancement of gender equality, it's again quoted the proposition that it's a major goal and therefore very weighty reasons would have to be put forward before such a difference in treatment could be compatible with the convention. So pausing there, my lords, my ladies, the point we make around this authority is that that proposition that difference in treatment on grounds of sex requires very weighty reasons is established prior to the JD case.
I might say all the more reason for equalising the pensions of women and men.
For the purposes of our claim, my lord, the point that's being taken against us is that JD does not stand for a consistent line of authority. The point I'm making on behalf of the appellants is that that is not a fair way of reading it, and that it does sit as based on pre-existing Strasbourg principles and authorities, and that in fact much more recently there has been more domestic consideration of this issue.
Do we have the Markin case itself?
My lords, I don't believe you do. You have room to, but we can provide you with the Markin case if you need it as well. I'm happy to make that available to my lords.
We don't need to look at it beyond it. Just, if you're saying it is the fons et origo of this line of authority, it might be sensible just for us to have it or not.
Forgive me, we'll make that available to you. My lords, I think we'll have separately, I don't know if my lords and lady have put this in at the back of the authorities bundle, but a request was made yesterday for you to be given the Court of Appeal authority from April of this year in the Joint Council for the Welfare of Immigrants case. I hope that was provided to you separately yesterday. I don't know if you've put it at the back of the authorities bundle or if you have it loose.
I'm sorry, I wasn't able to print it, so I'll have to read it on screen.
Do you all have that recent authority from the Court of Appeal?
Not yet, but
I'm not sure that I do.
I think it was provided to the court yesterday by the respondents.
If you give me a minute, it was sent to me by email at 3 o'clock yesterday, 14:59. But that's from my clerk, so
correct.
My lord got it as well.
Yes, I have it also sent to me at roughly that time.
It's very well, and yes.
My lord, we can perhaps liaise with your clerk and make it available to you if you
Well,
don't.
I think. Sorry, I don't want to be. Telltales out of school. I think I can see an email that was sent to my lord at 14:58 yesterday.
All right. Well, if there's any further difficulty, my lord, we can make that available to you, because I suspect my learned friends will refer to this authority as well. Are you content, my lord, for me to proceed? If
Yes,
you don't
of
have
course.
it in front of you?
Absolutely. Yes, you go ahead.
My lord, this authority is from April of this year, and so post-dates consideration of the JD case in Strasbourg, and in our submission gives you a helpful review of the way in which the manifesto without reasonable foundation test has been looked at domestically. And so my learned friends had asked for you to have regard to paragraphs 125 to 141, and they do take you through perhaps a reminder of some of the ways in which in authorities such as MA and DA, the manifesto without reasonable foundation test has been looked at. And there are quotes from some of the earlier authorities, in particular Humphreys is quoted, and then one gets to 132, where JD itself is quoted at paragraph 132, which is, I think, the passage I've just taken my lords and my lady to. And there is broadly, just pausing there and hopefully summarising it helpfully, discussion about the types of cases where manifesto without reasonable foundation is an appropriate approach or not, and broadly about whether it properly extends beyond the welfare benefits sphere. So my lords, my lady, may not be too troubled perhaps about that part of this judgment, but what we would submit is a resistance is perhaps for you to look, please, at paragraphs 136 and 139, because at paragraph 136, Lord Justice Higginbotham says this at 136, that he did not regard the question of whether manifesto without reasonable foundation applies or not as a simple binary question. And he quotes an earlier judgment by saying this, that the area of judgment afforded to an arm of the government depends on the nature of the ground on which the difference in treatment is significantly based. So pausing there, this treatment of the manifesto without reasonable foundation test makes clear only a few months ago that if it is based on gender, the difference in treatment, then the reviewing court will look with especial intensity for particularly convincing and weighty reasons to justify that treatment. And so,
pausing here, though, that is based on gender. That's the language of ordinary direct discrimination. Here, you're not saying that the treatment you complain of was based on gender. What you're saying is that for the kinds of reasons you've identified, it has a disproportionately adverse effect on women because, to put it crudely, they're poorer. Is that the kind of situation that my Lord Justice Higginbotham was referring to in Akbar, or indeed in JCWI?
well, my lords, we would rely on the proposition that gender is well recognised as generating a special need for intense scrutiny and care. And on the facts of this case, given what has been placed before the court around the impact on this group of women, that it is necessary to apply this level of scrutiny to the decision. And that this very compendious paragraph goes on to recognise that other factors are relevant, such as the objective of the measure, and no doubt the context in which these decisions were taken, therefore, is relevant, and concludes by saying that those matters also bear on the appropriate intensity of review by any reviewing court. And just finally on this, over the page at 139, there is a quote back to the SC case, which my lords, my lady have at tab 44, and it is quoted there that Lord Justice Leggett had recognised that the manifesto without reasonable foundation test is not met simply because the measure has a legitimate aim and is rationally connected to that aim. It must also be a proportionate means to achieving that aim. It thus still requires a balancing exercise of the end and means. And so our submission, my lords, my lady, is that given the gender element to the indirect discrimination complaint that we make, that it is necessary for the evidence to be focused and looked at with special intensity, and that is the test that the court below should have applied to the justification element of the sex discrimination analysis, and that the court below erred in not doing that. So, my lords, we've made our submissions, my lords and lady, in our skeleton on that, but just to perhaps assist, I hope, finally, if one can just look at the way in which the court below dealt with this issue. One can see, please, it begins at paragraph 73, and it's primarily 74 of the judgment below at page 86. So 73 deals with the contextual factors I think we've already looked at, but paragraph 74 of the judgment below sets out the way in which the court dealt with justification. And in our submission, the reasoning at paragraph 74 does not amount to the proper level of scrutiny that I've already quoted from Langford and would reiterate from the Joint Council on Welfare of Immigrants case I've just taken, my lords and my lady, too, was required. And so that's perhaps the third of the reasons, my lords and my lady, why we say the court erred in its approach to the justification test. My learned friend Mr. Straw will make perhaps further arguments around justification based on the evidence, but on the legal propositions, my lords and my lady, that is what I submit on behalf of the appellants in relation to sex discrimination, and I repeat the points I've already made around the CEDAW evidence that should have been looked at. So, my lords, my lady, those are my submissions on the convention elements of the age ground and the sex ground, unless there is anything in particular that I can further assist the court with.
Oh, thank you very much.
Can I just be clear in my mind? You started on when you were moving to the sex discrimination case on Article 14. You said there were three parts to your case: the pool issue, or the comparator, and the ESOP and JD, and what is meant by that. Then one of them was the nature of the justification test.
Yes.
What was the one in between?
Forgive me, my lady. It's on page 26 of the skeleton. It's the disadvantages rooted in traditional norms and cultural traditions and cultural norms. And the reason that we've dealt with the arguments in that way, my lady, are because the court below approached this as a three-stage analysis and essentially said the claimant's claim failed on the pool because of those cultural norms, and then on justification. So it's those three limbs that we have followed through. And I'm sorry that we have jumped around a little bit, my lady, but the reason why they're numbered 2, 3 and 4 in the skeleton is because, as my learned friend will take you to after lunch, number 1 is the EU law argument. So, and he will develop that for you after lunch.
Yes, thank you.
If that pleases the court, unless there's anything else I can assist the court with.
No, Miss Hill, thank you very much indeed.
Thank you. Thank you, my lords, my lady.
Right, so it's 5-1. I think the sensible thing, really, is to adjourn until 5-2, so that we can start afresh at 5-2 with Mr. Straw.
Thank you.
Let's do that. We'll adjourn until 5-2. Thank you.
Thank you, my lords, my lady.